information or opinions expressed. User bears full responsibility for their reliance on such content, information, or opinions.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Good evening, South Florida. Hey, I hope everybody is okay. Boy, what a last 2 days we've had. It's just been crazy, and I got to tell you, our prayers go out to all those people over there on the West Coast. We actually have a show in Tampa, and it was actually called off because of the weather. But we got a great show tonight. Kaye Rembaum has been with us for almost 6 years. It's the very first show of each month, and by your phone calls and by your letters, it is without a doubt one of our hottest shows. We had your email saying, why aren't you doing it every week? But we have other shows, though. But we had a time slot came open, and we are so excited. We added another Kaye Rembaum show. It's the last one now that we do, the last show of the month. So if there's 5 weeks, it's the 5th week of the show. So tonight is Kaye Rembaum, and we have two of the attorneys. One is Jeff Rembaum, that should say something, and then we have Danielle Brennan. They're both board certified. Jeff Rembaum was on our show about 2.5, 3 years ago. He already tried to get me today. That's okay. We'll get him tonight. Anyway, welcome. Welcome. Are you now, Jeff? See, we can see everybody. Are you in? Is this your office?
It is.
It is. You're into guitars.
Mandolins, yeah.
Mandolins. That's right.
A while back, yeah.
Wow. And then he has all these books, makes it you think he's read them all, but we know better. We got to smile at him.
A lot of books in there, a lot of binders, a lot of...
Yeah. And Danielle, are you at the office?
No, actually, I'm here in my home in Wellington, and it's as a result of the school closures from the storm. So, but they'll be back there tomorrow. Thankfully,
Are the horses okay?
Very bad here.
Are the horses okay?
I don't own any.
But Wellington
I'm horse adjacent in Wellington.
A lot of people own horses in Wellington. Okay, so what we're going to do tonight is we've got all these questions from listeners. But before we go to that, Jeff, tell people a little bit about your background.
Sure. I've been doing community association law for over 20 years. The reason you don't see me much on the radio is I'm a prolific writer. So I've been published over 300 times. And I let my partner, Robert, spend the most time with you.
Yes.
Because he writes sometimes. But I'm putting out a lot of articles and trying to keep your listeners and our listeners informed on what's happening. So I'm really curious to hear what's on their minds today. I am board certified. Been very, very involved in this practice for a long time now. We have offices as well, Kaye Rembaum in Miami-Dade by appointment, Pompano. We're in Palm Beach Gardens, and we're also in
Tampa?
Hillsborough. And a little secret, we're starting to open up Orlando, but we're not ready really to talk about it quite yet.
Okay.
But we have our attorney secured, and we're working on the build out. And when we're ready, we will announce it and make it official. But it's exciting.
Well, I think things are really changing from the legislator, and we'll talk about that tonight. Danielle, tell everybody a little bit about yourself.
Well, I am also board certified specialist in condominium and plan development law. I've been working with Jeff and in the Palm Beach Gardens office for nearly 10 years now, although it
God
doesn't
bless
feel
your
like
soul for
that
that.
long. It doesn't feel like
How do
that
you put
long.
up with him?
You know, our weird matches. What can I say? You just find someone whose weird matches your weird, and we make it work for nearly 10 years now. And I'm very glad to be here. And I also want to extend my sympathies and well wishes for everyone who's been affected by the hurricane.
Well,
Most
I'm going to
certainly.
tell you all, we've been doing the show for a long time. We get so many law firms that call us up and say, "Hey, I heard you had Kaye Bender Rembaum on. I want to do a show like that too," which we don't need them. We've got you. But when they always say nothing but good things about your firm, which is not always the case. But when it comes to association law, even the people out there say what a great firm you all have.
Thank you, Steve.
Thank you.
Okay, so what I'm going to do, here's how we're going to do it. I am going to ask each one of you questions, and I'm not going to go in any certain order. The only thing is I'm going to
The
say,
answer is C.
what's that?
The answer is C, Steve. Steve-O, the answer is C.
Oh, okay. Let me just write that down. How do you spell that?
C.
I'm going to keep up with you tonight. I'm going to tell you.
You're gonna have to.
So, okay, we got to start off with Danielle because she's
Sure.
at home with the kids and no horses.
Yeah. Hopefully you can't hear them shouting downstairs.
No, not at all. Yeah, I know you got them gagged and their hands are tied behind their back. It's okay.
No, I set my husband on them. So,
Oh, well,
if
I
they-
want to say one thing because a lot of people don't understand. When you say you're board certified, you did a lot of extra educational classes. I mean, it's not everybody who's board
yeah,
certified.
the process is intensive.
And you're an expert. You can literally call yourself an expert. Not all attorneys can do that.
Yeah, it was an intensive process. You have to have practiced. I think the minimum cutoff is 5 years, and then you have an application process, peer review process, and then you get cleared to sit for an exam, which is like a bar exam, but for your practice area. And then you anxiously sit and wait for the results. So yeah, it was a big relief and an honor when I was finally, when I took my
And
exam and found out that I had passed.
Jeff,
So,
aren't most of the attorneys, not all, but aren't most of the attorneys at your firm board certified?
Well, we have about 21 attorneys, and 10 of us are board certified. 9 of us in this body of law, condominium and plan development. Plan development is a nice way of saying homeowner association cooperative, right? So condo, HOA, cooperative laws. And one of our attorneys is board certified in construction law as well, and does a lot of construction litigation. So we have 3 main departments in the firm: collection foreclosure, which you need to have for the clients to collect the assessments,
Right.
a litigation department, which includes construction litigation and a variety, you can't imagine the variety of litigation that occurs for community associations. And then what I refer to as the desk practice. When the clients call, sort of like this, playing stump the lawyer, you never know what's going to be on the other side of that phone call.
If you'd like to call in right now, our phone number here is 888-565-1470. Are you having a lot of your clients call you up to come make a presentation on the new legislation that I guess goes into effect the end of 24?
I tell you, that's an interesting question, and we got out ahead of the curve. So we've done several webinars. My partner Michael has done them, I've done them, and we have another one coming up. I think the date is October 17th, where we're going to take 2 hours, and I'll have myself, and I'm going to go through in detail Senate Bill SD4, which includes the structural integrity reserve study as well as the milestone inspection and break them down into their minute components. And then for the listeners that are on that, last time we did it, we had about 500-600 people. I expect to have the same. They can then ask their questions through the chat channel, and then we start addressing them one by one as best we can within the time frame that we have. We've also put out a publication. Rembaum's Association Roundup also put out an in-depth explanation on Senate Bill SD4. So it's on our firm website. It's at Rembaum. If you go a shortcut to get to Rembaum's Association Roundup.com, you can get there through kbrlegal.com, and it's in our publications. You can get there by going to rembaumlaw.com. Any of those will bring you right to the database, and there's a whole over 200 and some odd articles are sitting from prior days in that database. That all you have to do is type in the word that interests you, and then you'll find an article on that subject.
Hey, if you're just getting out of college and you haven't decided what you want to do, become an engineer, because they're not going to have enough engineers to go to these, the high rises, or you're above 3 stories, to go
That's
in there and do an assessment.
Yeah. Do we have enough? We're all going to find out. Some people say, yes, we do. Some people say, no, we don't. I think about 80% of the people I speak with don't think we have enough engineers, and about 20% do.
Right. Hey, let's go to the phone. Great. This is a great caller to our show. Good evening, Barry. Barry from Miami.
Barry. Hello, Barry.
Hi, Barry.
Jeffrey, how are you? Hi, Danielle.
Very well.
Congratulations.
Nice to have you on the phone with us tonight. Barry is a regular
Hi,
listener and
Steve-O.
attendee of our webinars.
Hi, Barry. Now, you were an attorney. Is that right?
Yes, an ex-attorney.
Okay. I'm going to sick you on him, Barry.
You're going to stick me on him? Okay. It's December 31st, 2024. Our condo is subject to the new statute. They're not going to do a structural integrity reserve study. They don't want to fund reserves. And nobody from our condo is going to report them to the DBPR. What's going to happen?
What's going to happen? Are you really going to sit back and let that happen, or is this just a hypothetical you're making up? Because I think your building is going to be one of the first one to do all those things.
Let's call it a hypothetical, okay?
I think that's probably a little more realistic. So really the question is, what do you do if the association simply blows it off? And there's a lot of perspective to look at this from. Let's say the lawyer learns that. What is the lawyer's obligation? And remember, the lawyer doesn't represent the board. A lot of people, and hopefully not your listeners, Steve-O, because I know you have an educated base listening today, but the lawyer doesn't represent the board. The lawyer doesn't represent the individual members of the associations. The lawyer represents what I call the company, the corporation, the association. Before that declaration ever got recorded, a company was created with the Florida Department of Corporations. The lawyer has a duty to the company. In this instance, what would the lawyer's duty be? It would be to write to the board of directors in its entirety and say, hey, wait a second, guys, once this has come to the lawyer's attention, and let them know that this is a potential breach of fiduciary duty, that they are exposed in a personal capacity method. And I think usually when the directors understand that their own personal liability is on the line, right? Breach of fiduciary duty. It doesn't get much worse than that. I think you would then see a change in behavior. I don't believe the lawyer could go ahead and, for lack of a better way of expressing it, rat out the association to the Division of Condominium. That would not be appropriate. And I really do believe, having done this for so long, every community has at least one person that will go to the division. There's always one. So there will be somebody there to make sure the association does what they should do. Let's hope they do. The other thing that could happen, Barry, is you could also contact the upset member where the association isn't doing what they should be doing, should be in touch. It could be with local news. It could be with the Division of Condominium. It could be with the local county or city commissioner as well. And remember, too, when it comes to the milestone inspection, there's going to be a letter coming to you from local government, and there'll be local government breathing down the neck of the board of directors to at least make sure the milestone gets done. So I don't really think we're going to well, we might get that far really with some associations blowing this off on its entirety. And if they do, then we're all going to find out together how that is dealt with on a grand scale.
I just have one comment. KBR is the best.
You are Barry. If we had a fan club, you are its founding and member for sure. So we
Thank you, Barry.
Barry is so intelligent. His emails.
We have a line open now at 888-565-1470. Let's go to Kim in Aventura. Good evening, Kim.
Good evening. How are you doing today?
We're doing fine.
So my question is, I live in a community that has 160 units. It's 2 buildings. We just had a vote of material alteration where 84 people voted. So that would be the majority. However, 10 of the votes were invalidated by the monitor. Now, it was brought to the association's attention by myself and another resident that because we ended up with 74 votes because of those 10 invalidated votes, that the vote was invalid. And I sent an email to the property manager and the attorney, and their explanation is that because 84 people actually voted, then it's a valid vote.
That doesn't sound quite right.
Right. Before Danielle answers your question, I just want to point out we're not giving specific legal advice to your situation. We are going to address anybody's call today in a generic nature. If you want specific advice, you need to reach out to your own private attorney to help give you that direction. So I just wanted to throw that out there before Danielle answered your inquiry.
Absolutely.
Yeah, and I also wanted to point out that you're talking about material alterations in a condominium context, and you said it was a majority approval. Well, that's also something that's very specific to your own declaration of condominium, because pursuant to Florida statute in 718-113, it's unless otherwise provided in your declaration, then the approval you need is actually 75% of the unit owners prior to the association being able to do the material alteration to the common elements or the association property. So that's something that's specific to your governing documents, and generally it's approval, not necessarily just the votes cast. And if there's an issue regarding material alteration, if they were to go forward with it, the proper venue for something like that would be with the Division of Florida Condominiums, Timeshares, and Mobile Homes in an arbitration setting, or potentially through pre-suit mediation, which is now an option under the amended statute.
And I'd add to that that you could have some wonky, before she does, you could have some wonky language in your governing documents that led to that conclusion. What if the governing document said something like, a majority of all owners must cast a vote, all right? And then it required a percentage of those people in order to pass the material alteration. So we don't have the benefit of your governing documents. But if you have an experienced community association lawyer, do not mention who it is. I don't want to know. But you do know. Look them up. Go to floridabar.org. See if they're board certified in this field. If they are, then, and you know from firsthand experience what the lawyer said, then chances are the lawyer is right. If they're not board certified, but they're in this field as a matter of practice every day, they still might be right. But as Danielle said, you certainly do have remedy that you can discuss with private counsel.
Okay, the governing document that was shared in the voting packet indicated that we would need 51%.
Well, I understand, but there's still language. We can't take it any further right now without actually diving in and actually reading that language for ourselves. Not what the voting package said, but actually what the declaration of condominium or the what it actually said. So I think we've done as much as we can on here.
It sounds like at this point you need someone to actually sit down with you and go through everything, because it is very fact intensive. And particular to your condominium, like I said, statute provides some language, but it's going to be in your declaration and in the actual materials and how everything went down, that you'll ultimately find your resolution to that.
Great
Okay.
question, though. Great question.
All right. Well, thank you for your help. I appreciate it.
Thank you, Kim.
Thank
Hey,
you.
let's go to Bob in Jupiter. Good evening, Bob.
I've used you in the past. I've been a board certified for an HOA. I'm talking about a homeowners association up here in Jupiter. Basically, what I want to know is the board has said in the past, and now keeps doing this over and over again, that somewhere along the line the Florida statutes changed and basically said they only need to give you a 2-week written notice for any change of the documents or any change of the material aspects of the buildings, and don't give you any data until the day of the 5-member vote. For example, I'll just give you the biggest one or two. They decided to change all of our roofs, asphalt roofs, so over 600 to be metal roofs. And they just went ahead and put out the nice study, basically passed the study, and they said the day of the vote or the day before the vote, they handed you a 15-page document and said, here's the reason why we're going to do it, and they did it without a vote. I already know that's not right. My question is, can they give you only a 2-week notice for any change of documents or any changes at all? Is that a Florida statute?
So it sounds like what you're asking is for board meetings, because it was a board vote, correct?
Correct.
Okay.
In other words,
So what it
our
sounds like
document
is
originally
you're
said all
asking about
600
board.
and plus after vote, but they're avoiding that.
Well, I
Well,
can't
they
speak
make-
to that.
they
I don't
make
really know the circumstances around that, but I can give
they
you a little bit
basically
more
go back and
information and
say
guidance when it
The
comes
Florida
to
statute says we only
board.
have to give you 14 days notice.
So yeah, for board meetings, the typical board meeting notice is a 48-hour posted notice on a conspicuous place within the community. There are certain instances in which a 14-day notice has to be provided to the members, sent out to the membership, and that's for adoption of rules regarding parcel use and my brain is blanking on me right now. Non-emergency special assessments.
Right. But Danielle, in this case, I'm thinking that the board was changing, possibly, in addition to approving the material alteration aspect, we're probably amending the architectural provisions.
Architectural, yeah.
Yeah.
Yes,
So what's
That's what
that?
it sounds like.
Basically said
And
because it's not
potentially
structural. Go ahead.
potentially it was them amending or altering the architectural control covenants or architectural control guidelines, standards and guidelines for your community, which in our world would trigger that need to provide a 14-day notice, because arguably it's a rule regarding parcel use. So that type
But
of
is the
board
Florida
meeting would
statute
require
allow
a
that?
14-day notice.
Yes, on
In other
a
words,
generally
there's a difference
speaking.
between a material alteration of going from 600 asphalt roofs to all being metal roofs without a vote of the community, I think, is wrong.
Well,
We
you
did
have to
that
talk
without
to
a
the
Well, you're in
Florida.
an HOA though.
Right.
This
So
Yeah,
is
unless
you're
the
in a
governing documents-
homeowners association, correct? Not a condominium.
We're an HOA.
If you're in a
correct,
condominium
homeowner
association, then yeah, there is that statute that we were just talking about, which unless your declaration of condominium provides otherwise, it's a 75% approval requirement at the membership level. But in a homeowners association, there is no corollary for that in the statute, and that is entirely governing document based when it comes to alterations.
Which is
And
why,
for the
good
most
sir
part-
and caller, you should run for the Florida legislature. Why should material alterations in a condo require 75% vote unless otherwise set out in the governing documents? But in an HOA, it's exactly the opposite, so that no vote of the membership is required whatsoever unless required in the governing documents. So the board is vested with the power to make the decisions of the material alteration. So in your case, let's hypothetically say that the declaration has no guidance whatsoever. The board makes the decision. But in this instance, they're changing the parameters or the rules, if you will, as to what is permitted. So that required the 14 days notice, and that requirement was to be posted and sent to you in advance of the meeting, which they did, and then they voted.
There also may
They
be
could do
some
that
other
anything. For
provisions in your
example, right now,
declaration
what
of
they did
covenants
is
at
they went
play.
ahead and said, well, guess what? We want the HOA offices to have metal roofs, which of course is more expensive than an asphalt roof. And they, without notice, without the 14-day notice, they just went ahead and said, oh, we decided to go ahead and do this. We already collected the bids, and we're picking the highest bidder for doing the metal roof. And it's going to cost XYZ. I know what the dollars are. They're going to cost XYZ dollars. And they just went ahead and voted 5-0 or 4-1, and basically doing that too, which obviously
You'd have to have an attorney look at everything in order to make sure it was done according to Hoyle, as they say. But generally speaking, if they first had a 14-day notice meeting and changed the rules, then they could do a 48-hour meeting and approve the roof contract. Personally, I'm happy as heck. I changed my asphalt, not an asphalt, but an S-barrel tile, ceramic, to a metal roof about 18 years ago, and I know I have at least another 15 or 16 years. Now, the insurance companies may not like it, but my roof looks just as good and is just as strong as day one. So in the long term, I'm a huge proponent of the metal roof. So it's probably saves money in the end.
I have to admit, I'm one of the guys who did it, but there's a lot of people in our association who can't afford an extra $12,000 for a metal roof, and they actually tried to stop. It made it mandatory that you had to have metal roofs rather than asphalt. Now, we actually stopped that with enough people without lawyers like you, and said, we've had enough of this. You're not going to do that. But at the same token, they do this over and over and over again, at least 3 or 4 or 5 times, and basically said, we're ignoring everybody, and we're just going to vote 5-0. And
so when are you going to run for the board? When are you going to run for the board? When are you going to run for the board?
Congratulations. I've already been on the board in the past. I'm retired. And
that's right.
And I'm thinking about it, but be honest with you, I've already paid my dues, so I'm trying to find some other people to do it. Regardless, what you're saying is the 2-week notice works for everything, is what you're saying.
No, not for everything, but in this instance, it sounds like it may have been correct. Remember, we don't have the benefit of reading your governing documents. I've seen documents that require a longer notice period. In this case, they went with the statutory minimum, which would be the 14-day notice posted and sent to all the members in advance.
Well,
but we appreciate you calling.
They have to give you 30-day notice, but that's actually for enforcement of whatever they actually decide to.
Yeah, that's a different provision.
Yeah. Okay. All right. Well, who knows? Maybe I'll come back to you one of these days and decide to run again. But
thank you for your support over the years.
I not necessarily want to hear, but you're saying the only remedy is to contact the Florida.
Well, the remedy for an HOA is to talk to a lawyer who's knowledgeable and say, hey, here's what happened. I've had plenty in the past. I don't do it so much anymore, but in the past, I've been hired by plenty of owners who just wanted to hire me for a few hours to look through something to see if it was done correctly or not. And I got to tell you, 80% of the time, at least, it was in those situations.
Well,
sometimes not. But
okay, that's fair enough. I appreciate the info.
Yeah.
Thanks, Bob.
And thanks again for the support, Bob.
Danielle, can you give everybody your phone number at the office?
Sure. It's our Palm Beach Gardens office number is 561-241-4462. And
that website address?
It's www.kbrlegal.com.
Okay, we're going to go to break now. We got a board full of calls. Joan, you will be up first when we come back from break. We'll be right back.
Kaye Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kaye Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kaye Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kaye Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
Oh, Steve-O.
And we are back. See,
Steve-O, did you hear that?
I've
Did
got
you hear that commercial?
What's that? I didn't hear what you said.
Oh, did you hear the commercial? They were just advertising and coming on to a family law presentation for divorce. That's not us.
I know. We do have other shows here. I want to listen. First of all, let's go to Joan because she's been holding for a while. Good evening, Joan from Fort Lauderdale. Are you there, Joan?
Is that really requiring us to have 10 individual reserve counts as they listed the 10 items?
Joan, come back to us. You have to ask the question again.
You can't hear me?
We can hear you now.
Hello?
Yes, we hear you.
Yeah, the SIRS, do we have to have 10 individual reserve accounts for those 10 items they list that will be inspected?
Well, it depends if your property is 3 stories or higher in height. But if it is, then the answer is yes. Roof, load-bearing walls, floor, foundation, fireproofing and fire systems, plumbing, electrical, waterproofing, exterior, windows, and any other item with a deferred maintenance expense or replacement cost that exceeds $10,000, etc. So generally speaking, the answer to that question is yes.
Are they going to expand what is required, or are we just going to go blindly get an architect in to say, what do you mean by plumbing? What are you going to check for plumbing?
Well, exactly. We're going to leave that up to their professional expertise. There is a visual inspection component of the structural integrity reserve study, and that portion does have to be done by an engineer. It's the architect or engineer who participates in the milestone, but the engineer has to do the visual inspection on the SEERS study. Shorthand, if you want to sound like you're in the business, we call it a SEERS.
SEERS, okay. And here's a quickie.
You are correct,
The notarized
SIRS.
affidavit for special assessment, besides the official records, where else is it filed?
The SIRS? Where is the SIRS filed?
No, the special assessment, there's an affidavit. It has to be notarized. I was wondering, besides the official records, where else does it get filed?
With the board meeting minutes from that meeting, which comprise a part of the official records.
So
It
that's
just
all.
stays with the
Okay.
association's records.
Got you.
You're talking
Thank
about
you.
the affidavit of mailing.
Well, it's an affidavit where it says it was notarized, where it says the president says his credentials and that the assessment is for so much money, and it's notarized. I just saw the first one, and I was wondering
Not
where else
really
I'm
sure
doing the
what you're talking
filing.
about.
I'm not sure what that is.
But
So maybe that's
if
just something the board's doing here. Okay.
right. And then it would still be
Okay.
part of the official records at that point.
All right. Thank you. Bye-bye.
Thanks, Joan. We have a line open now at 888-565-1470 if you've got a question for Jeff or Danielle. Kaye Bender Rembaum. You know, I saw a high-rise the other day that if it's 3 floors or higher, starting in 2025, is that right?
For which issue, Steve?
For the, if you
The milestone or the reserve study?
the reserve.
The reserve study you have to have completed by December 31st, 2024, and then it has to be in your 2025 budget.
But right across the street, it looked exactly the same way, but they were rental apartments. They don't have to do anything, do they?
Well, not according to this legislation anyway.
I mean,
You
this
make
is
a
supposed
really
to
good
be a
point.
safety issue, checking, make sure we don't have another.
Right. But I don't know what the hotel, for lack of a better word, let's call it a hotel. An apartment building. I don't know what their compliance standards are. I don't know if there's any kind of corollary. Certainly, the Miami-Dade inspections would, the 40-year building certifications may trigger into that as well.
Okay, let's go to one of our listeners, Monty in Boca Raton. Danielle, what are the pros and cons of a condo having its own maintenance man instead of using the management employee?
So, as we were talking about earlier, I think one of the main concerns that boards always have is liability. I think if the association's board is considering hiring someone, it really needs to think about an employee policy, because we're finding that to become more of an issue for our associations about having an employee policy and enforcing it, even if you only have one employee. Now, of course, management of that employee, if it's done by the management company which they're employed by versus the association is going to have a lot more intensive management and oversight over that particular person, as opposed to the person who is hired by the management firm and provided by the management firm. But I think it's really a question of liability, and it's an administrative question too, because now you're dealing with payroll, income tax issues, where that would be taken care of by the management company. Not to say that there's not still liability for that particular person if it's retained even through a management company, but at least you have that layer and that administrative layer when it's through a management company. But you really have to see if it's a right fit for you, because it'll be more time intensive to have the employee under the association without the management layer.
I don't know if it's the show or what, but we used to get so many calls about service animals. We don't seem to get as many anymore, but I do have Karen in Boynton Beach. She wants to know, what would be the liability to the condo if a dog bites someone? How much insurance should a dog owner carry?
Well, I don't think we're talking about service animals, which really, when people use that term, are really talking for the most part under the ADA. Under the FHA, we have assistance animals, which includes the emotional support animal and service animal. But generally speaking, that's going to be up to the owner of the animal. The association has no ability whatsoever to make it a requirement for approval. We will approve your assistance animal, but only if you have a $1 million policy. Nope, that'll get you in big trouble with the Fair Housing Authority. Can't do that. None of the normal pet rules and regulations apply to the assistance animal, including the emotional support animal subset and the service animal subset.
I'm starting to hear a lot from associations. Like, here's Jack in Hollywood. What happens when nobody wants to be on the board, but the actual members have reached the 2-year mandate? What do you do?
Well, if there's no one to run for the board, what's the attorney's final obligation? Remember, the attorney represents who? The company, the association. If there's no one to run for the board, in that instance, the attorney needs to go and basically file for a receivership right before they resign from the representation to say, hey, judge, this company has no board at all. That issue aside, if that is the case, has the association been enforcing that year after year after year? Can they amend their governing documents to now provide, to come up with a different regime, a 3-2-1 regime, so it's not everybody's running every two? Lots of different ways to slice and dice that issue. I think that with some creativity and some legal help from especially attorney Danielle Brennan, they can probably get through that issue.
I was actually just about to add to that about the term limits. At least from a statutory perspective for the condominium association boards, yes, there is a term limit that's provided by statute. However, there are a couple of caveats to that, one of which is you don't have enough eligible candidates to fill the vacancies on the board. So even under the statute where there's a term limitation for condominium board members, you're not going to run into the issue of, well, oh, I've reached my term limit. There are 5 vacancies, and I'm only one of 2 people who wants to run for the board, or 3 people, whatever it is. You're not going to be made ineligible simply because you've reached your term limit under the statute, because there aren't enough eligible candidates to fill the vacancies. So they do have a couple of caveats to that term limitation in Chapter 718 for our condominium association boards.
And if there were a 2-year term limit in the declaration or the bylaws, typically where you'd find it, and nobody wants to run, come on, really? Nobody wants to run? What happens when we send a letter out and say, hey, we're going to put you into a receivership if someone doesn't step up, and it's going to cost you guys a whole lot of money? Will people come out? If no one's going to run and that board is going to stay on, maybe they stay on a 3rd year while they're trying to get people to run. Maybe they agree to continue to run, but only on condition that if someone else steps forward, they will resign. So clearly it's a complicated issue. There isn't a bright line answer to the question, but I think you need to involve the association's legal counsel to help them through that situation.
What if you start paying them? You think that'd make a difference?
You want to have paid directors. I'm okay with paid directors, but only if the governing documents allow for it. And in my little perfect world, it would be a professional. In other words, their job 24/7 is they can be an officer or director of X number of associations. And that would be their, just like I'm an association lawyer, they would be a professional board member with a heightened sense of training. I don't favor the idea of paying board members, which is not allowed anyway unless the documents provide for it. But I don't favor the idea of paying folks that live there.
We're going to go to a quick commercial. When we come back, maybe kind of, because, I'm hearing board members that still don't understand some of these new laws are going into effect, which I was shocked about. And you know what? A lot of the residents are saying no one's explaining these new laws to us.
They need to go to kbrlegal.com and
Yes.
see what our webinars are, because we offer those kind of courses for free all the time.
That's right.
kbrlegal.com.
And in fact, I think Peter's doing one next week. We have an expo in West Palm.
When we come back, maybe do you have your schedule for October yet of your classes and seminars?
Well, we'll just go onto the KBR website and see what's there.
Okay, let's go to break. We'll be right back with more Kaye Bender Rembaum.
Kaye Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several Kaye Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. Kaye Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact Kaye Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
Wrong commercial up there. They keep saying now we're going to go back to the show with Tina. Danielle, unless you've changed your name to Tina, I think they have the wrong advertisement going on.
Okay, now we asked you guys first. Okay, so we did give you a shot.
What is there a message there for us?
I got turned down, but you know what? You're still our best client, though. I got to tell you, because we're in 8 cities, and I got to tell you, your show gets more calls and more letters than any show I've ever even been associated with. And that's pretty incredible,
Wow.
especially with people, their busy schedule. And you guys take the time out every month to sit here and educate people. You know, you do a lot of seminars, a lot of free seminars. And can you tell us what's going on for October?
Sure. October 4th, it will be at the Palm Beach Condo and HOA Expo. We're doing a course on guest restrictions and screening tenants and new owners. Is it worthwhile? We're doing a legal update course, and you get 2 CEUs with that one. On October 6th, you'll like this one, Steve. You should go to this one, Steve-O. On October 6th, we have a live radio show, Ask the Experts with Robert Kaye. On October 10th, every Monday morning, we have Peter Mullengarden on Condo Solutions on your AM dial. Oh my gosh, on October 12th, another one at the Bradenton Area Convention Center. Guest restrictions and legal update on that day. October 17th, another radio show, Condo Solutions. Let's see.
October 11th, actually, looks like there's a Broward Condo and HOA Expo at the Signature Grand.
Michael would be mad if I didn't mention that. Thank you so much for capturing that one. And there's a legal update that day, too, at the Signature Grand. That's going to be a great show. What was that date, Danielle? That's October 11th.
On October 11th.
That's great. And if Michael is down there and my partner, Andrew Black and Emily Gannon and Lisa McGill, shout outs to all of them. They do awesome seminars. And then on October 27th, we have our very own Sean Brown in Tampa. Hopefully that show will still be going on given what's happened, but we'll see. And there'll be a legal update at that Tampa condo and HOA. All of this is available. Just go to kbrlegal.com, click on the KBR calendar, and all of this is right there for you, even you, Steve.
Who does the morsels?
Robert Kaye, when he feels like it, will write legal morsels. I write Rembaum's Association Roundup.
Roundup, yes. Okay, so we have about 9 minutes left. Tell people about, I know you talk about this all the time, but the legislator has put together some new laws that are going to affect a lot of people, especially on condos. Can you give the short version of the changes that are getting ready to happen over the next 2 to 3 years?
Well, I'll jump in and say that in the Senate Bill 4D, there really are like 3 parts to it. I'll mention the first one because it's the date that's coming up the quickest, is the registration requirement, the reporting requirement with the Division of Florida Condominiums, Timeshares, and Mobile Homes. If you're, you can go to their website. I think they actually have the link live now where you can report your condominium, the number of stories your condominium is. And it is also part of that legislation that has the milestone inspections, as Jeff was touching on earlier. If you need a milestone inspection, you will be provided with a letter from your local government, which triggers a 180-day clock to get that milestone inspection done. You start with the phase 1 milestone inspection, which is generally a visual inspection done by a architect or an engineer. If during that phase 1 inspection, they discover any substantial structural deterioration, then you would need to do is phase 2, which could be visual, could be destructive, non-destructive. It's really left to the discretion of the expert to determine how thorough that particular phase 2 inspection is going to be. And once the milestone inspection is done, the inspection report has to be prepared and provided to local government and the association and kept with the association's official records for at least 15 years. We touched upon the SIRS earlier, and there are likely going to be some glitches, some cleanup changes in the upcoming legislative session. But generally speaking, a condominium which has 3 stories or more, is going to be required to have this SIRS done by December 31st, 2024. Now, the SIRS report, the SIRS is a structural integrity reserve study. The person who actually does the reserve study just can be a reserve study preparer, somebody who's qualified to do that, and has that visual inspection requirement that Jeff was touching on earlier that has to be done by an engineer. And
Jeff is actually on the phone now.
Yes, sir.
Oh, okay.
I hit
Okay,
that's
on my computer
that's why
that
it's
threw me
still-
off, so I called back in.
Oh, okay, gotcha. There is a list of items that have to be included within the SIRS, like the roof, like the painting, like the foundation. And there are a lot of questions as to how those items need to be accounted for that remain unanswered. But once you have the SIRS, it looks like you're going to have it redone every 10 years. Those particular items in the SIRS will have to be reserved for. You can't waive or reduce those reserves as of that December 31st, 2024 date. And you can't vote to use those funds for those particular reserves for any other purpose.
No more kicking the can down the road, is there?
Not for all those items. Nope.
This has to be done now.
Yeah. Like I said, there are gonna be some changes, and I know that a lot of people who own condominiums are cautious, concerned about what's going to happen financially, and that's absolutely warranted because so many associations, as you say, kick the can down the road. But hopefully there will be some changes. I heard chatter about potentially doing a phase, and I'm not sure. But we shall see what happens with the cleanup to this particular new piece of legislation.
Hey, Jeff, do you like the new legislation?
I can add to what Danielle said that there are some glitch bills that people are working on. And you never know what the legislature is going to do, but these glitch bills are not going to change the deadlines. They're not going to go substantive and make substantive changes. They're just going to make clarifications on what the existing bill is. And that said, you never know what a legislator might do and what kind of bill they may put forward in terms of making changes to the Senate Bill 4D. But I haven't heard or read a single shred of evidence that would make me think that there will be some type of substantive changes. So if those folks are sitting out there listening to think, yeah, they'll extend it again, just like they did the fire safety and all of that we went through a number of years ago, I don't think that may happen right now, most especially. We just had almost a Cat 5, right? 2 miles an hour away from a Cat 5 hit the coast. I have a feeling this law is going to go in and go hard pretty quick.
So do you like the new legislation?
The legislation is what it is. That really doesn't matter, right? We all have to live with it now. So we have to get behind it. We have to understand it. And we have to help our clients comply with it.
Let's give everybody the phone number at the office.
Our office number?
Yes,
Go ahead.
office number.
Go ahead, Danielle. Give them Pompano if you got it.
Oh,
You can
boy.
call
Of
9.
course you'd ask me to give Pompano. I don't know Pompanos, but I can tell you Palm Beach Gardens, 561-241-4462.
And our main number, 954-928-0680. Either number will get you to the same place. 954-928-0680 or 561-241-4462.
This has been a treat, both having Jeff on and Danielle. I hope you guys will come back again. There's an open chair for both of you. It's Kaye Bender Rembaum, and they'll be back with us again next week with Robert Kaye. Thanks so much, guys.
Thank you very much.
And Happy New Year to all of our.
Thank you. Happy New Year, everybody.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.